Late in the evening of July 28, 1996, while Rowena was sleeping in their house, accused appellant arrived. He was intoxicated and immediately came near Rowena, who was then only half asleep. He was wearing only his briefs. He awakened Rowena and began to undress her. He told her he was going to kill her. As accused appellant grabbed her, Rowena was forced to lie down. He kissed her, removed his briefs, and according to her, raped her. After the incident, Rowena left their house and told her aunt, Domitila Nolasco, accused appellant's sister, what happened. Domitila brought Rowena to the chapel and forthwith reported the incident to the police. Accused appellant was detained on September 17, 1996, but he did not know the reason for his detention. Neither did he know why Domitila and his daughter would file the rape case against him. Feeling embarrassed by the accusation against him, accused appellant went to the office of the barangay captain for advice. The barangay captain told him to go to the police station. He did as told, but he could not confront Rowena because Domitila had hidden her from him since the first Saturday of September 1996. The issue in this case is whether or not accused appellant is guilty of the crime of rape defined and penalized under Article 335 of the Revised Penal Code in relation to Republic Act No. 7659 and Republic Act No. 8353. The ruling of the Supreme Court. First, it is clear from the facts of the case that based on the documents submitted by the prosecution and the defense, the crime of rape was not committed. As defined by Article 335 of the Revised Penal Code, the law then in effect at the time of the commission of the crime, rape is committed by having carnal knowledge of a woman under any of the following circumstances. First, by using force or intimidation. Second, when the woman is deprived of reason or otherwise unconscious. And third, when the woman is under 12 years of age or demented. The crime of rape shall be punished by reclusion perpetua. As a general rule, the factual findings by the trial court deserve a high degree of respect and will not be disturbed on appeal in the absence of any clear showing that it overlooked, misunderstood, or misapplied some facts or circumstances of weight and substance which could alter the result of the case. However, a judicious review of the records of this case shows that the trial court overlooked some material facts and circumstances warranting the modification of the decision. The prosecution has failed to discharge its onus of proving, beyond reasonable doubt, the guilt of accused appellant for the crime of rape. Specifically, the evidence presented by the prosecution does not conclusively establish the first element of carnal knowledge. Despite the lengthy testimony of the plaintiff, she failed to mention how the alleged sexual intercourse was consummated. There was a total absence of proof that there was the slightest penetration of the female organ, not even the barest subliminal touch. When her testimony reached the critical point to demonstrate carnal knowledge, all that she said was that she was raped without even a modicum of details how the act was done. As it is, the bare statements of Rowena that she was sexually assaulted or raped by accused appellant are not sufficient to establish his guilt for the crime of rape. Said statements fall short of the requirement of the law on the quantum of evidence required in the prosecution of criminal cases. The medical certificate and the testimony of Dr. Rivera likewise do not establish a degree of moral certainty the guilt of accused appellant for the crime of rape. Dr. Rivera could not categorically say that the laceration on the hymen of Rowena was caused by the penetration of accused appellant's penis. The court cannot make this statement the basis for holding accused appellant liable for rape because in criminal cases, speculation and probabilities cannot take the place of proof required to establish the guilt of the accused beyond reasonable doubt. Suspicion, no matter how strong, must not sway judgment. Dr. Rivera unequivocally stated that Rowena was not suffering from psychosis. Thus, other than the mere mention of the word psychosis in Dr. Rivera's testimony and accused appellant's self-asserting claim that his daughter was mentally disturbed, there is no independent evidence that would lead to the conclusion that Rowena was an incompetent witness due to her abnormal mental state. Even granting that she was indeed mentally disturbed when she testified, mental incapacity is not an absolute basis for the disqualification of a witness. And soundness of mind does not per se render a witness incompetent. One may be medically or metaphysically insane, yet be capable in law of giving competent testimony in the trial of a case. The general rule is that a lunatic or a person affected with insanity is admissible as a witness if he has sufficient understanding to apprehend the obligation of an oath and is capable of giving a correct account of the matters which he has seen or heard with respect to the questions at issue. However, notwithstanding the prosecution's failure to prove accused appellant's guilt for rape, the court holds that there is sufficient evidence to convict him for acts of lasciviousness under Article 336 of the Revised Penal Code. The elements of the crime are: Number 1, offender commits any act of lasciviousness or lewdness. Number 2, that it is done by using force and intimidation, or when the offended party is deprived of reason or otherwise unconscious, or when the offended party is under 12 years of age. And number 3, that the offended party is another person of either sex. Although the information was for qualified rape, accused appellant can be convicted of acts of lasciviousness because the crime of acts of lasciviousness is included in rape. Rowena clearly testified that, wearing only his briefs, accused appellant approached her while she was half asleep and kissed her. With lewd design, accused appellant grabbed Rowena and then undressed her. He also threatened to kill her. All of the elements of the crime of acts of lasciviousness are therefore present and have been sufficiently established. Wherefore, the decision of the Regional Trial Court, Branch 66 of Capas Tarlac, in criminal case number 1139 is hereby modified. Accused appellant Rogelio Caingat is found guilty beyond reasonable doubt of the crime of acts of lasciviousness as defined and penalized under Article 336 of the Revised Penal Code and sentenced to suffer the indeterminate penalty of 6 months of arresto mayor as minimum to 6 years of prison correctional as maximum. Accused appellant is likewise ordered to pay the victim, Rowena Caingat, the amount of 50,000 pesos as moral damages plus costs of suit.